Welcome to Bond University on iTunes U.
Good morning, ladies and gentlemen, and Patrick, thank you very much for that generous introduction. A particular word of thanks to you and all of your colleagues for inviting me to come and take part in this colloquium in such a marvelous environment and with such warm hospitality. I'm told this is your winter period. You should come and try Scotland in the winter. Another reason, of course, for being grateful to you is that you will have gathered that there's a major sporting event going on in London at the moment. And when Vivian and I were discussing this, we thought, where is the furthest that we can get away from London? And just then Patrick popped up and said, why don't you come to Bond? Last night, yesterday evening, the principal talked about how this university, and particularly the law school, is at the cutting edge of research. And that is nowhere more true than in this whole field of the detention and the particular nature of detention, which we're going to discuss through the course of today. Currently, this is a major issue which is at the crossroads between politics, good governance, human rights, and prison reform. The whole question of how do we deal with the other? Who is or who are the other? There's a wide variety of definitions of the other. People who increasingly in different countries and jurisdictions are subject to one or other form of preventive detention. I've been doing some work recently with the United Nations International Crime Research Institute, which is working with the US State Department on what it calls violent extremism, which is code for Al-Qaeda and Islamic so-called terrorists. That's one example of this phenomenon. A week or two ago, I was asked to take part in a colloquium in Argentina, where the major issue is what they quaintly called physical safeguarding of prisoners. Physical safeguarding is a euphemism for locking prisoners up in total isolation when they are thought to be a risk, a threat to other people. In so many parts of this debate, one comes across these euphemisms, these terms, which actually hide the reality. And of course, as we've just seen so dramatically, you have your own issues here in Australia. This morning, in opening the colloquium, Patrick has asked me to speak in general terms to give you some thoughts about the use of imprisonment, the nature of imprisonment, the form of imprisonment, which can, I hope, set the context for the more detailed discussion which will come later. Let me start with a personal anecdote. Almost 40 years ago, I first walked through the gates of Edinburgh Prison in Scotland. I found myself in a world of which I had no previous knowledge, a world which existed in parallel with, but quite separate from the everyday world which I shared with millions of other people. And from that very first day, I found myself asking the question, what is the purpose of imprisonment? Throughout the following 25 years, I moved from prison to work, and in due course, I governed several of them, including two of the most iconic prisons in the United Kingdom. In the late 1980s, I became governor of Peterhead Prison in Scotland. At that time, Peterhead held all those prisoners who had been assessed as being the most disruptive and dangerous in the Scottish prison system. All of them had been involved in riots, in taking hostages, or in attempting to escape. When I went there as governor in 1987, I walked into a world where there was continual violent confrontation between staff and prisoners. The normal daily uniform for staff consisted of a riot helmet, body armor, and carrying perspex shields. The prisoners were locked up in isolation for 23 hours a day. Many of them wore only blankets. Some of them were covered in their own excrement. Many prison systems have a particular prison which is the end of the line, frequently called the hate factory. Peterhead was that prison in Scotland. Some years later, I was appointed governor of Brixton Prison in London. Brixton is the oldest prison in London, built in 1819. I went there in the immediate aftermath of a violent incident in which two IRA prisoners shot their way out of the prison. Shortly before I went there, the European Committee for the Prevention of Torture had carried out an inspection of Brixton Prison, and it had concluded that the conditions in which the prisoners were being held were inhuman and degrading. I'll never forget the first day that I walked into F Wing in Brixton Prison. F Wing at that time held 230 prisoners who had been remanded in prison by the court for psychiatric assessment. Physically, the walls were painted bottle green. There was permanent semi-darkness, which meant that the artificial light had to be kept on all day. There was an all-pervading smell of urine, feces, and stale food. And the noise was an unrelenting cacophony of keening, wailing, shouting, which went on all day and all night. In each of the cell doors, there was a large flap, which was usually kept open. And out of that flap appeared a face, usually a black face, desperate for human contact. If a man was not mentally disturbed before he went to F Wing, he certainly was after a very short period there. And to go wider, for many years now, my work in the International Centre for Prison Studies has been in the international arena, and I have been a close observer of prisons and imprisonment in every region of the world. In the 1990s, I spent a lot of time in prisons in Eastern Europe and Central Asia, in the countries of what had previously been the former Soviet Union. In those countries, prison overcrowding did not mean 3 prisoners in a cell built for 1, as it had meant in Brixton. It meant 3 prisoners to a bed. Prisoners slept in shifts, 8 hours sleep, up, someone else for 8 hours, up, someone else for 8 hours. There were bunk beds tiered to the ceiling, crammed into rooms with little air and no natural light. Conditions which were breeding grounds for infectious diseases such as tuberculosis and later HIV/AIDS. To the extent that one Minister of Justice in Russia described being sent to prison as equivalent to being sentenced to death. I've also visited prisons in sub-Saharan Africa and in Southeast Asia, prisons built in the 19th century by colonial powers which are still in use today. Prisons where there is no running water, where there's a drastic shortage of food, where prisoners languish for years waiting to get to court because the authorities don't have sufficient transport or fuel to take them to court. I've seen prisons in Western Europe which are medieval castles, totally inappropriate for the 21st century. I've seen prisons in Latin America where violence is endemic, where staff do not go inside the prison to where the prisoners are unless they are fully armed. Places where the violence among prisoners is such that there will be several murders each week. I've been to prisons in the United States of America where prisoners spend their entire day locked in complete isolation with no human contact, some of whom will do so for the rest of their lives. So, after 40 years in and around the prisons of the world, I still ask myself, what is the purpose of imprisonment? And increasingly, I have come to realize that if I, with all my experience of prisons, am unsure of the answer to that question, is it any surprise that courts, politicians, and the public are even more uncertain? Having set the scene, let me now say something about the stated purposes of imprisonment. Why is it that some persons who are accused or convicted of crimes are sent to prison and others are not? What does the court mean to achieve when it sends someone to prison? This question about the purpose of imprisonment is very important because unless there is clarity about this key issue, it will be difficult to discover whether or not prison is effective. If we wish to know whether or not prison achieves its purpose, we have to understand what its purpose is. Traditionally, as many of you will know, at least 4 purposes have been suggested. Sometimes they have different titles, but in broad terms, they are punishment, deterrence, reform, and protection of the public. Let me say a few words about each of them. The first given purpose of imprisonment of convicted persons is to punish them for the crime which they have committed. The argument in this case is that some crimes are so serious that the only appropriate disposal for the court is to punish the offender by depriving him or her of liberty. In the majority of countries in the world, including Australia and the United Kingdom, imprisonment is the most punitive sentence which a court can apply. And the criminal law is usually quite specific in restricting the court's authority to impose a prison sentence. The sentence of imprisonment carries great symbolism in the eyes of the public. When a judge sentences someone to be taken down, very often the convicted person is seen to be taken directly from the dock physically downstairs to the cells. In high-profile cases, the press will photograph the prison van swinging out of the yard of the court and later swinging into the forbidding walls of the prison. The clang of the prison gate carries a resonance in the mind of both the public and the prisoner, which is different from every other punishment. Throughout most of the 20th century, in many countries, including Australia and the United Kingdom, there was broad acceptance of the principle that the punishment intended by the court when it passed a sentence of imprisonment was deprivation of liberty alone. Being required to stay behind the high walls of the prison for the period specified by the court, not being permitted to go out of the prison other than in exceptional circumstances, that in itself was a heavy punishment. In the words of Alexander Patterson, a famous prison commissioner in England in the early 20th century, he said, "It must be clear from the outset to all concerned that it is the sentence of imprisonment and not the treatment accorded in prison that constitutes the punishment. Men come to prison as a punishment, not for punishment." This principle, of course, does not apply in all jurisdictions. The law in the former Soviet Union, for example, required the court to specify as part of the sentence the type of regime under which a prisoner would serve his or her sentence and the severity of the treatment which was to be meted out. And that provision remains in a number of countries in that region. In the United Kingdom, a House of Lords judgment in 1982, which is frequently referred to as the Wilberforce Judgement, confirmed that the punishment involved in imprisonment is not absolute, but is restricted in its nature. The court said, "A convicted prisoner, in spite of his imprisonment, retains all civil rights which are not taken away expressly or by necessary implication." Now, while this is all very well as a principle, there is, of course, great room for interpretation about which civil rights are expressly or by necessary implication taken away by the fact of imprisonment. That indeed is a worthy sentiment, but what does it actually mean in practice? What does it mean, for example, in respect of the right which all human beings have to family life? In the United Kingdom, this right is severely limited when a person goes to prison. Direct family contact will be very restricted. It will be quite infrequent. It will probably consist of short visits taking place in a very public space with very limited physical contacts. But that's not the case in all countries. In other jurisdictions, the arrangements will be made to allow families to spend extended periods, often up to 2 or 3 days, living in special flats or units inside the prison, living together as parents, spouses, or children. That sort of arrangement is as yet unthinkable in the United Kingdom. In the United Kingdom, the press and the public would regard such arrangements merely as an opportunity for prisoners to have sexual relations. And what would be left of the pain of imprisonment if that were to be allowed? In other countries, the focus in these matters is not merely on the prisoner, it's also on the right of his or her children, parents, partners, friends, to have these sort of relationships. Take another example. An example which is very live today in the United Kingdom, that of whether prisoners should have the right to vote. In the majority of countries in Europe, either all prisoners have the right to vote, or those who do not have the right to vote have the limitation applied on an individual basis. Yet, in the United Kingdom, our Prime Minister has said that even to contemplate such an arrangement, never mind to introduce it, would make him, in his words, physically ill. Looking in more general terms, the coercive nature of the prison environment means that the punitive element of imprisonment extends into many features of daily life. Even inside the prison itself, prisoners do not have the freedom to circulate. They are likely to be told where they can go, when they can go, what they can do, what they cannot do. And the point being made by Alexander Patterson 100 years ago was that it is not the task of the prison system to impose punitive regimes on prisoners as part of their sentences. But the truth is that imprisonment is a blunt instrument of punishment, and it affects individuals in different ways. For some, the pain of deprivation of liberty itself and separation from family is almost unbearable. For others, especially some who usually live their lives at the margins of society, prison may be almost a haven, a place of safety from the pressures and severity of external life. But whatever the personal reaction, there is little argument that imprisonment as punishment is the main feature of deprivation as liberty. And I'm sure that I suspect that we will return to that theme in the course of today. So that's a comment on the first given purpose of imprisonment, punishment. The second given purpose is what we call deterrence. Now, the choices which most of us make in our daily lives are affected very often by what we see as the consequences of our actions. This means that sometimes we are deterred from doing something because of what we think might be the adverse consequences, and that the consequences would outweigh the benefits of what we propose to do. We might, for example, decide not to smoke in case we contract cancer. We may decide to cut down alcohol consumption because of the damage that might be done to our liver. And sometimes the consequences are legally imposed rather than being a direct consequence of our actions. For example, driving at high speed through a built-up area might well cause an accident. The likelihood of causing an accident may be sufficient to cause most of us to slow down, but not everyone. And so there is a law which determines that everyone who is caught speeding will be fined or will suffer penalty points. The possibility of that happening is enough to deter most of us from speeding most of the time. And it's a similar argument which is applied in terms of deterrence when it comes to crime and imprisonment. If a person who commits a crime, who's tempted to commit a crime, knows that the result is likely to be a period of imprisonment, then that may well be enough to deter the person from committing that crime. And the greater the punishment, the greater the deterrent. It might be argued, for example, that the prospect of 1 month imprisonment would be enough to deter someone from stealing, let us say, $200. But it wouldn't be enough to deter them from stealing $200,000. To deter someone from stealing that amount of money, the prospect might have to be several years in prison. And the same principle is applied to different levels and types of crimes. There are, of course, two forms of deterrence: individual deterrence and general deterrence. Individual deterrence is when I, as an individual, am deterred from doing something, from committing a specific act, because of the danger that I will be sent to prison. General deterrence occurs when we see someone else being sent to prison and we say, I will not do that act in case the same happens to me. When we're discussing imprisonment, the principle of deterrence is an important one. But we also have to remember that it is based on a premise, the premise of detection. If I know that no one is likely to check the speed at which I'm driving, then I'm more tempted to drive perhaps quicker than I should. The same happened certainly in the United Kingdom when speed cameras were first introduced. The public knew that many of the speed cameras had no film in them, and so the deterrent effect was reduced. Along came digital cameras, and the prospect of detection went up. And so with the increase in detection comes increase in the power of deterrence. At least that's the theory. But there is evidence that even a high probability of detection is not sufficient to deter people. And so the threat of prison, the deterrent threat of prison, as a means of crime control, let alone a means of crime prevention, is even more problematic. The statistics speak for themselves. Research by the United Kingdom government indicates that out of every 100 offences committed, 3 will result in a conviction or an official caution. And 1 out of 100 will result in a prison sentence. So, in the unlikely event that a potential criminal will apply these actuarial considerations, those are actually pretty good odds. The value of imprisonment as an instrument of deterrence, then, is questionable. It is true that we cannot calculate how many crimes are avoided because specific individuals are deterred from future offending. But the statistics do not give much cause for optimism. In many jurisdictions, a majority of all prisoners, and we heard something of this last night in specific cases, but a majority of all prisoners will be reconvicted of a further offence within a very short period of release from prison. So that's deterrence. The third stated purpose of imprisonment is reform, personal reform. This concept of prison as a place of reform grew from the 19th century onwards. Often it was encouraged by the claims of those who worked inside the prison system. Now, the notion that prisons can be a place where individuals are taught to change their behaviour is attractive on a number of counts. In the first place, it provides a positive justification for sending a person to prison, so that something will happen which is much more than pure deprivation of liberty. The notion of prison as a place of personal reform is also attractive to public-spirited men and women who work in prisons and who wish to do more professionally than simply deprive people of their liberty. And the notion of prison as a place of reform becomes even more attractive if it is linked to the notion that crime can be traced to a specific group of individuals. If crime is seen as a series of acts committed by a relatively small, identifiable group of people, people who are different from the majority of law-abiding citizens. If that is the case, then the objective of changing their behavior as a result of the experience in prison should, so the argument goes, lead to a reduction in crime in general. This argument has also proved very attractive to politicians who need to find a way of responding to public fear of crime. Now, the notion that individual human beings can be encouraged to change their patterns of behavior for the better is a sound one. But whether this can be done in conditions of captivity is very problematic. Personal change comes about as a result of personal decisions. It's not something which can be imposed against a person's will. In the constrained environment of the prison, it is very difficult for an individual to make a truly free decision. And even when prisoners do have the ability to make some personal choice, they have to weigh carefully the consequences of that choice. For example, agreement to take part in a particular course or program in prison, or refusal to do so, may mean that the person will be given more or less privileges, may even affect the date at which a person is going to be released. And in the oft-quoted aphorism about prisons, one cannot train a person for freedom in conditions of captivity. The reality is that prison is essentially a world set apart from normality. The prisoner's link with the social structures which the rest of us take for granted are at best tenuous. It would be wrong to suggest that an individual, particularly a young person, who has had problems at home, problems in school, problems in the workplace, problems in social relations, as many prisoners have had throughout their lives, can be changed by a few months in a prison and then sent back to the world from which they came as a reformed individual. It is true that in many prisons, staff carry out sterling work in attempting to provide prisoners with opportunities to change themselves and their behavior. And a few individuals may indeed be changed for the better by their experiences in prison, but they will always be a small minority. And it can be argued that such change comes about despite the prison environment rather than because of it. There is an additional danger in regarding the prison as a place of reform rather than of punishment. And that is that it will be used increasingly as a place to detain those whom society finds difficult. People who have mental health problems, people who have substance abuse problems, people who are homeless, or in this globalized world of ours, people who are stateless. People who are in some way or another regarded as a danger to the law-abiding majority. People whom I said at the outset can be defined as the other, the different. And this is an issue which we're going to discuss throughout the whole of today. And then finally, in terms of the purposes of imprisonment, the issue of public protection. Prison works, so the argument goes, because during the time that offenders are in prison, they are prevented from committing other crimes. The argument is known usually as incapacitation. And in some respects, this is valid, particularly when we are considering crime in specific neighborhoods where a significant proportion of crime is created by identifiable individuals. However, that sort of crime in particular communities tends to be low level and as a result to attract relatively short prison sentences. The person may be taken out of their community for a short period of time, but are likely soon to return to it. This isn't a new problem. In the first half of the 20th century in the United Kingdom, we had a sentence of preventive detention, which involved specific prisoners, specific offenders, being given additional sentences because of the repeat nature of their offending. The legal provision for this was eventually rescinded because it was seen to be both unjust and also ineffective. And an added problem today is that many of the crimes which destabilize communities are not resolved by extracting one or two individuals. For example, when a drug dealer is removed from a local neighborhood, it will often be a matter of days, if not hours, before he or she is replaced on the street by another dealer. There's also an issue of public protection in respect of people whose behavior is such that it presents a continuing and present threat to the safety of society. Some of these people may already be in prison, having been convicted of serious crimes, particularly violence against the person, and they may give every indication that if they were to be released, they would continue their offending. Now, the reality, thankfully, is that the number of people within any one community, within any one society, even within any one country, such as Australia, is likely to be quite small. And these individuals will probably be known almost by name because of the high-profile nature of their offending. What is important is that decisions about any of these individuals must always be taken in an independent judicial forum and based on rigorous evidence. Again, something which we heard of yesterday evening from Professor Petrilla. There's another group, of course, of people who are in prison, people who have been charged with a crime but have not yet been tried or sentenced. They are sent to prison on grounds of public protection in the broad sense of that term. The grounds may be the likelihood that the person will abscond, that the person will interfere with the course of justice, either by putting pressure on witnesses or in other ways, or even that the offence is so serious that the person must be detained while the court process proceeds. For prisoners such as these, there is a raft of international laws and standards, as well as domestic law, which deals with prisoners who are awaiting trial. I won't go further into that concept today, other than simply to state that we must bear that group in mind very much when we are discussing imprisonment. What we must be certainly aware of is that in respect of those prisoners, the sole purpose of detention must be public safety. It cannot be any of the other objectives which I have described. And that brings me finally to the problematic group that we are directly concerned with in this colloquial. Those who have not committed a serious crime, perhaps even a crime at all, but who have been identified by experts as likely to do so. This is really a problematic issue, with experts expressing considerable concern about the basis on which decisions concerning these individuals are made. In the United Kingdom, for example, these include a small number of persons detained without charge under terrorism legislation. And Vivian Stern this afternoon will refer to these cases in more detail in her presentation. And we've already heard several references to people in this country detained under dangerous prisoners legislation. Let me conclude. In any jurisdiction, decisions about the use of imprisonment are not purely a matter of criminal justice priorities. They are also affected by the views which a society has about social justice and indeed about the nature of society itself. Prisons do not exist in a vacuum, nor is their use determined in an entirely dispassionate manner by courts of justice. Prisons are symbolic institutions. The level at which they are used and the people who are sent there has much to say about the attitude which a society has towards what are acceptable levels of punishment, about punishment as a social phenomenon, about approaches to the treatment of people while they are being punished, and about the international legal framework within which prisons should operate. My last thought. What is clear is that the deprivation of liberty, which is at the core of imprisonment, is per se a punishment. To talk of imprisonment which is not punitive is an oxymoron. It is a contradiction in terms. It cannot be true. Thank you very much for listening.
For more information, visit bond.edu.au/iTunesU.